Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin LLP, located in Toronto. As you know, I've been with you many times. As I always say, we have offices in Ontario, in British Columbia, and Alberta. So we are spread out in several provinces and cities, and we help fix your workplace issues. And the goal for today is to answer as many employment law questions as possible. So please, I urge you to ask your questions, post them in the chat, and I will try to answer them to the best of my ability. And I want to try to get through as many questions as we can. Before we do that, I always like to start off with an interesting topic. And throughout the session, I'll talk about interesting topics impacting employment law right now. So the first one is this idea of masking. And, you know, many people would think that COVID-19 is over. Some people have different opinions on that. That's really not the purpose of the discussion today. But nevertheless, what we are seeing is that people are masking up again. And there's a case out of Montreal where an employee was masking and the employer didn't want her to mask. And as a result of that, she resigned her employment. And so this raises the question of whether employees have the right to mask in the workplace or not. Can your employer challenge that? And so long as you don't have an actual accommodation from your doctor that you need to wear a mask, then your employer can say that they don't want you to mask. Now, every case is different. So it really depends on what your situation is, what industry you work in, whether you have a medical need to wear a mask or not. But currently, the government is not mandating masking. And so your employer is allowed to make rules that are consistent with that. But again, this does not apply across the board. It depends on your specific circumstances. So if you're a person who maybe is immunocompromised and you have a medical note saying that you need to wear a mask, then your employer has to accommodate that. Otherwise, you could be dealing with a human rights issue. Your employer might be liable to pay you human rights damages if you bring a claim because of that, so long as it's actually documented by a doctor or a medical professional saying that you need this kind of accommodation. So that's just an interesting thing to think about, especially as I said, we're seeing people mask up more and more these days as the flu season hits, etc. So let that percolate in your minds and let me answer some questions. So we have a question from Sam on Facebook. And Sam says, I've been working for a company as a commission salesperson for 20 years. I've been a top salesperson year after year. Now they're adding an extra person to share my shift, even though sales and commissions are down across the board. This will lead to a big pay cut. What can I do here? Interesting situation. So typically your employer can hire whomever they want, right? If your employer thinks that for some reason they need to hire more employees to get the job done, they're able to do that. However, in this case, if it is impacting the amount that you get paid, then you potentially have what's called a constructive dismissal case. And let me explain what a constructive dismissal is in general, and then we'll tie it back to Sam's situation. So a constructive dismissal in general is a situation where an employer implements significant changes to the terms of your employment, and you don't agree with those changes, and your employment contract doesn't say that the employer is allowed to implement those changes. Well, then in that kind of case, you don't have to agree with the change or changes. You can fight the changes and you can seek your full severance pay. Okay, so a typical example would be a pay cut. So tying it back to Sam's situation. If you are earning year after year $100,000 and as a result of some situation, whether your employer just wants to reduce your pay or profits are down, so they want to reduce your pay, whatever the case might be, if they go and do that and you don't agree to it, you can treat that change to your pay as a constructive dismissal of your employment, and you can seek your full severance pay in that situation. And so we see constructive dismissal cases all the time. I deal with them on a daily basis. And there's other typical situations of constructive dismissal. It could be a change not to your pay, but to your duties, or to possibly the reporting structure in the organization, and how that impacts you. It could be a change to the work location. It could be a layoff that you don't agree with. All of these things are potentially constructive dismissal situations, so long as you don't agree to the change and you challenge it. And again, these are very common, unfortunately. We deal with them all the time. So Sam, I hope that answers your question. There is something you can do here. There is recourse. So if you would like to set up a consultation, please let us know. You can contact us at help@employmentlawyer.ca, and we'd be happy to chat with you about the situation in more detail. Okay, we have another question from Terry on YouTube. Is it against the law to fire an employee after they have announced their pregnancy? Yes, that is a human rights violation. If you make it known that you're pregnant, and within a short time frame, maybe the next day or several days later, you've had no employment issues, but suddenly you're terminated, there's a very good chance that it's related to the announcement of your pregnancy, and that is a human rights violation. As I said, you should be able to seek your full severance pay, and also human rights damages as well. But again, it depends on whether you can show that there is some sort of connection to your announcement of your pregnancy and the termination. If there's no connection whatsoever, then it's probably going to be hard to prove. But if there is a connection that you can draw, then this is a huge legal problem. So if you're facing this kind of situation, certainly let us know, and we will advise you further. So again, Terry, I hope that answers your question. If you have a follow-up, please post it in the chat, and I'll do my best to get to it. Okay, Cindy on Facebook asks, I have worked for a dentist for the past 30 years. After seeking legal advice, I recently declined signing a contract since I have never had one before. As a result, I was given the option to sign a 24-month working notice contract or leave in 3 months. Do I have any other options here, or am I limited to what has been offered? You likely have other options. So this is an offer that's been made to you. It sounds as though they're offering you to work for 2 years, 24 months, or to leave in 3 months. I'm not sure if you leave in 3 months, you're being offered any pay. That's something that could impact this, but your options are not limited. You can potentially try to seek that this money comes in as a lump sum, not as working notice. It also depends on if the practice is part of a larger organization, potentially, that has a big payroll of over $2.5 million. In that case, your employer has to pay you severance pay because you've worked there for 30 years, which is more than the minimum amount of 5 years to get your severance pay. And if the employer has a large payroll of over $2.5 million, then they have to pay you severance pay as a lump sum. They can't just give you working notice. So again, it depends on your situation. Contact us, and we'll advise you further on this piece, Cindy. And if you have a follow-up question, then please post it in the chat. Okay. I think it's a good time for me to raise another important topic. And this is something we continue to see. I talk about it in all of these live stream sessions. I know that my colleagues do as well. And it's the idea of a mass layoff and what rights you have in a mass layoff situation. And what I want to focus on is what happens when your employer is really facing some significant financial difficulty. Does that impact how much severance pay you're entitled to? And so in short, it doesn't impact how much severance pay you're entitled to. If your employer is not bankrupt, but they are going through a challenging time and they're laying off employees as a result, it doesn't mean that you're entitled to less severance pay than you would otherwise be entitled to simply because your employer is going through difficult financial times. The law has been very clear on this point. You are still entitled to your full severance pay in that case. And it doesn't matter if your employer is going through financial difficulty. Now, if your employer files for bankruptcy, that is a practical problem. It's going to be hard to obtain money in that case, even if you're owed severance. There are some channels that allow you to seek your severance pay even in the case of bankruptcy, but practically speaking, it's more challenging if your employer is bankrupt. But if they're not bankrupt, and again, they're just suffering financially, you're still entitled to your full severance pay. Now, I've been talking about full severance pay throughout this session. So let me now talk about how severance pay is actually determined or calculated. So severance pay is determined based on various factors. And those factors are your age, your length of service, the position you held, how much money you earned, generally the availability of similar employment opportunities in the industry at the time of termination. So that is how severance pay is determined. There's no exact algorithm that says you get 1 month or 2 months or 2 weeks per year. All of that is really nonsense. Severance is determined based on those factors. Now, as you saw, it was posted on the screen before, we have a very handy tool known as the Pocket Employment Lawyer. And as part of that Pocket Employment Lawyer, you can determine how much severance you specifically are owed in your case using what's called our severance pay calculator. Now, that calculator is going to ask you basic questions based on the factors that I just described. So it's going to ask you about your age. It's going to ask you about your length of service, your position, how much money you earned, etc. And then it will tell you a general frame of how much severance you're owed in your specific circumstances. It's a free tool. It's an anonymous tool, and you can use it whenever you want. You can use it if you've been terminated. You can use it if you haven't been terminated, and you just want to get a sense of what severance pay you'd be entitled to if you were terminated. It's a very handy tool. Definitely check it out. Again, it's the severance pay calculator that's part of our Pocket Employment Lawyer. So you can see it on the screen, pocketemploymentlawyer.ca. Okay, let's jump into more questions here. So we have a question from Frank. Frank says on YouTube, I hurt my back recently and have been working from home. We're not being asked to come to the office for at least 3 days a week. I've been told I have to get a doctor's note, otherwise I have to come in. I don't understand why this is happening, as I can do my job perfectly from home. Okay, this is actually something I wanted to talk about today. So, Frank, I appreciate you posting a question about it. Let's put aside your back issues for a minute. We'll deal with that. But let's just say you're an employee who's been working from home. Maybe you've been working from home when a lot of us started to work from home during the COVID-19 pandemic. So can your employer ask you to come back to work? Generally speaking, they can. Your employer can say, we want you back at work. It could be full-time. It could be part-time. It could be multiple days a week. It could be you get to choose. You have to come in 1 day a week or 2 days, but you get to choose which days. I've seen as an employment lawyer many different situations in the past couple of years of the kind of requirements that an employer has in terms of how often you have to come back to work. Now, like I said, an employer generally can ask you to come back to work. However, if you've always worked from home your whole career, and even if it predates the COVID-19 pandemic, when a lot of people started working from home, you've always worked from home. And now your employer is saying that you have to come to the office to work, then that potentially is another constructive dismissal situation where you've had it as a term of your employment that you work from home. That's your job. That's your location. But now they're changing that location and they're making it downtown or Scarborough or wherever it might be. That could be a situation where they're implementing a significant change to the terms of your employment, and you can challenge that. And you don't have to agree with it, and you can seek your full severance pay. Now, Frank, I said we'll come back to your back issues. We put that aside for a minute. If you are working from home because you need that as an accommodation, your doctor has recommended that you work from home, then your employer has to honor that. They have to accommodate you up to the point of undue hardship, which is a very high legal threshold. They have to accommodate you. And if your doctor says that's what you need as an accommodation, your employer has to do it. So even though generally speaking, an employer can ask their employees to come back to work, if you have a specific situation or set of circumstances, such as a medical accommodation, then your employer again has to honor that. Okay, Frank. So I hope that answers your question. Let me know if you have any follow-up questions. One thing I'll say is, Harinder, I don't think I saw your question. If you have a question and you're waiting for me to answer it, then please post it again because I don't see it in the chat. Moving on to question from MP on YouTube. I am not sure if this is a relevant question here, but employee wants to come back after eye surgery, was away for 7 days only. What would we need to allow the employee to come back full-time, part doctor's note, and clearance, Ontario? Okay, so this sounds like this is a situation that has occurred in Ontario. Sounds like MP, you are an employer. So if your employee has been off of work, they had some surgery, and they are seeking to come back to work, really you have to allow them to come back to work. If they have a doctor's note saying that they need certain accommodations as a result, you have to honor those accommodations. And in terms of clearance, that doctor's note should be sufficient. Again, it depends on your specific workplace, though. I don't know if you have a third claims adjuster that you deal with. There's various other elements to this. But generally speaking, you have to allow your employee to come back to work. You have a legal duty to do that. And if there is some sort of accommodation, you have to honor that. If you have any follow-up, then please feel free to post it in the chat. Okay. As we wait for more questions coming in, I want to talk about another important topic. And we've spoken about this before, but again, it's important to talk about these things and make sure that the audience knows about these important legal topics. And so this one is the idea of what an independent contractor is versus an employee. What we see very commonly is what's called misclassification. So someone really appears to be an employee, but there could be a contract in place, or they have some arrangement that they're being designated as an independent contractor. That could lead to significant legal problems. And what we've seen is most of the time, people are employees. Even though you might have signed a contract that says you're an independent contractor, or even if you invoice the company, I don't want you to think, if you're in that situation, that it means for sure that you're an independent contractor according to the law. The law also looks at other things that are very important, such as your hours of work. Do you have any flexibility about where you work, how you work? Do you have helpers that help you perform your job? Who pays for those things? Do you use tools to perform your job? Who provides those tools? Who pays for any repairs to your tools or resources? All of these things are important factors to determine whether you are in fact an employee or an independent contractor. Essentially, what the law looks at is how much control do you have over your job. The more control your employer has, which is common, then the more likely it is that you're an employee. So, I have a case going on right now where someone, worked for a company for 10 years. They worked 40 plus hours per week, and they dedicated their full time to this certain employer, and they were let go. They were terminated, and they weren't provided any severance pay. And the employer says, well, you're an independent contractor, and so you're not owed any severance pay. And that is not true. The law would disagree with that. The law would say that this person is an employee. They used the employer's workstation, computer. They worked there, like I said, 40 plus hours per week. They only worked for that given employer. So the law would say this person is an employee. And if you're an employee, you are entitled to severance pay. That is the key point. And so many people are in a situation where they think they're independent contractors. If you're in that situation and you're let go or terminated or laid off, certainly let us know, contact us about that, because there's a very good chance that you are, according to the law, an employee and you're owed your full severance pay. Okay, let's move on to another question. Can your employer terminate your job if you were on approved disability leave? Has been almost 2.5 years and they're saying they have no choice. Okay, great question, Keith. We also see this issue very commonly, that you're on leave, you could be on LTD, and your employer lets you go. It's usually around the 2-year mark that they do that. Could be less, could be more, but around that 2-year mark. And the employer says that they have to let you go. And what they usually call it is frustration of contract. That's a legal term. Again, frustration of contract. The employer says that we have no choice. It's not your fault, employee, that you're disabled and you can't work, but it's also not our fault as the employer, and we need to replace you. And as a result, we have to let you go. So in that case, it's potentially legally fine that your employer has done that, potentially. Often employers jump the gun and they'll let you go, even though you really could come back to work within a certain time frame. So I have a case going on right now where the employer did just that. They let my client go. They said that there's no prospect of my client returning to work, and that wasn't true. The employee, my client, had a doctor's note that says that they would probably be coming back to work very soon. Just not yet. And so the employer, like I said, jumped the gun in terminating this employee and tried to not pay them any severance pay. And in that case, you would be owed your full severance pay. Often in this situation, an employer only wants to pay you your minimum entitlements to severance, which is much less than what I call your full severance pay. And unfortunately, this is a common thing, Keith. So if you're in that situation where you are off on a leave, could be a disability leave, and your employer lets you go, don't sign anything. Contact us. Again, you can contact us at help@employmentlawyer.ca, and we will help you out with this situation and advise you as to whether your employer did the right thing from a legal perspective and whether you're entitled to more severance pay. Okay, Keith, I hope that answers your question. And if you have any follow-up, then please post it in the chat. Okay, we have another question. I'm happy to see so many questions rolling in today. This one is from Rolanda on YouTube. I was hired at a daycare facility to work Monday to Friday, 8 a.m. to 3 p.m. Over the last few weeks, I keep getting informed not to come in for random days from the director. Am I owed pay for these days? You should be, yes. If you were hired, if your contract says that you are working a given amount of time. So if your guaranteed hours are Monday to Friday, 8 a.m. to 3 p.m., then you have to be able to work those hours. Now, sometimes your employment contract might say that there is no guaranteed amount of hours. In that case, you could run into a difficulty here, Rolanda, because it could be that your employer is fine with what they're doing, which is telling you not to come in on certain days because you're not guaranteed any amount of hours. And as a result, you probably wouldn't be owed anything further. This is something that the Ministry of Labor could potentially help you with. They deal with these kinds of cases all the time. So you can contact the Ministry of Labor and they can assist you in determining whether you would be owed for any unpaid days. Again, as well, if you want to set up a consultation to discuss this situation further, just let us know, and you can contact us at help@employmentlawyer.ca, as you see on the screen. Another thing I want to mention is we have tons of resources on all of these topics, right? And you can go to employmentlawyer.ca and you can find all of these resources online on situations of constructive dismissal, of severance pay, wrongful dismissal, what happens if you're on a disability leave. We have resources on all this stuff, and it's important that you check it out. Again, of course, it's free, and you can learn more about your legal rights. And then you can set up a consultation with us, and we can discuss your particular issues. Okay, so as we wait for more questions to roll in, something else that I want to talk about, and this is a big topic, but we're going to try to scratch the surface, and that's the idea of a termination for cause. And I've talked about it several times on these sessions, and it's a very common issue. And what a termination for cause is where your employer says that they have a reason to terminate you, and that reason allows them to not pay you your severance. So could be that your employer says you stole from us and we can prove it, and therefore we're letting you go effective immediately, and we're not paying you any severance. So in that situation, you should challenge it, and we can help you do that and determine whether you're actually owed severance pay. Many times employers will terminate you for cause, and there isn't really cause to terminate you. So they're just saying that they don't owe you severance, but they really do. And a common thing we see is if your employer terminates you because of performance issues. That's a common one. Some employers will say, we're going to pay you severance anyway, which they should. Some employers, though, say your performance issues were so bad that we're not paying you any severance and we're letting you go. So in most cases, you will be owed your severance pay. So if your employer has said, you haven't been performing well, so we're letting you go, they still have to pay you your severance. Usually performance issues are not going to be justifiable to terminate someone without severance. You're still owed your severance. Also important is you have to have received warnings. You have to have gone through what's called progressive discipline. Your employer has to have implemented progressive discipline. So various warnings, maybe a suspension, maybe they put you on, if it's a performance issue, they put you on a performance improvement plan. All of these things should exist for your employer to be able to potentially terminate you for cause without severance. But especially if there have been no warnings, no performance improvement plan, no suspensions or anything of that nature, and they kind of just let you go abruptly without severance pay, and they're saying that they have cause to terminate you, you're likely owed severance pay in that case. Again, very common situation. Make sure that you contact us about that at help@employmentlawyer.ca. We're near the end of the session. Let me see if I can squeeze one more question in from Sloan. After a supervisor quit recently, I've been taking on additional responsibilities. I agreed to do so until they hired someone else, but it's been almost 5 months now, and I can no longer keep going at this pace. It's led to additional stress and hours. Can I refuse at this point? You certainly should talk to your employer, Sloan. If you did it as a temporary favor and you made that clear from the beginning that you would take on additional responsibilities, but now it's too much for you and you want to revert back to what your original responsibilities were, certainly speak to your employer about that. And if you need some sort of accommodation because of the stress, then again, speak to your employer about that. Get a doctor's note, and they should be accommodating you in that regard. Okay, I hope this session has been helpful. Join us again tomorrow at 1:30 p.m. with my colleague Dan, and you'll get your questions answered then. Take care. Thank you.